I am Gurshan Singh, the student of DPS Khanna. Today, I am going to show you my holidays homework of FFT on the topic Judicial System in India. These are the topics we are going to discuss in this video. So let's get started. There are three types of courts in India: Supreme Court, High Court and District Court. Indian judicial system. The three-tiered system of Indian judiciary comprises of Supreme Court at its helm, High Courts standing at the head of state judicial system, followed by district and session courts in the judicial districts, into which the states are divided. The lower rank of this system then comprises of courts of civil and criminal jurisdiction. This is the structure of judiciary. The Supreme Court. On the 28th of January 1950, the Supreme Court came into being. The judges of the Supreme Court at the time of inauguration were Chief Justice Harilal Jikania and Justices Syed Fazal Ali, M. Patanjali Shastri, Meher Chand Mahajan, Bijan Kumar Mukherjee, and S. R. Das. The first Attorney General for India was Mr. M. C. Shetalwat. The Supreme Court of India comprises the Chief Justice and not more than 30 other judges appointed by the President of India. The proceedings of Supreme Court are conducted in English only. The registry of the Supreme Court is headed by the Registrar General. Supreme Court of India. Appointment of judges. Judges are appointed by the President of India. They must be citizen of India. They must be High Court judge for at least 5 years or High Court advocate for at least 10 years or distinguished jurist. They must hold office till the age of 65. Removal of a judge. Article 124 of Constitution of India lays down the procedure for removal of a judge of Supreme Court, which is applicable to Chief Justice as well. He can be removed only through a process of impeachment by Parliament. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than two-thirds of the members of that House present, and voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. Article 124 Constitution of India. Guardian of the Constitution. Supreme Court enjoys the privilege of protecting the Constitution against violation of its provisions either by government or by the people. It acts as the watch toward the Constitution and also exercises people of interpreting the contents of the Constitution. The High Court. The High Courts are generally the last court of regular appeal. It has the power to supervise the subordinate courts falling within its territorial jurisdiction. The High Courts are courts of record. The subordinate courts. The subordinate courts are A. District courts empowered to hear appeals from courts of original civil jurisdiction besides having original civil jurisdiction. B. Session courts is courts of criminal jurisdiction having the similar scope of powers. The district court. The district courts of India are established by the state governments in India for every district or for one or more districts together, taking into account the number of cases, population distribution in the district. They administer justice in India at a district level. The district court is presided over by one district judge. In addition to the district judge, there may be number of additional district judges and assistant district judges depending on the workload. These courts are under administrative control of High Court of the state to which the district concerned belongs. The decisions of district court are subjected to appellate jurisdiction of the concerned High Court. Appointment of district judge and other additional and assistant district judges is done by the state government in consultation with the High Court of the state. A minimum of 7 years of practice as a lawyer at bar is a necessary qualification. District judges are also appointed by way of elevation of judges from courts subordinate to district courts provided they fulfill the minimum years of service. Village courts. Village courts called Lok Adalat or Nyaya Panchayat compose a system of alternative dispute resolution. Lok Adalat is a system of alternative dispute resolution developed in India. It roughly means people's court. The system of Lok Adalats is based on the principles of Panch Parmeshwar of Gram Panchayats, which were also proposed by Mahatma Gandhi. The idea of Lok Adalat was mainly advocated by Justice P. N. Bhagwati, a former Chief Justice of India. They are held periodically for exercising such jurisdiction as they determine. The first Lok Adalat was held on March 14, 1982 in Gujarat. The disputing parties plead their case themselves in Lok Adalats. Witnesses are not examined. No court fees is levied. Speedy justice is given to the people of all classes of society. It was the Legal Services Authority Act 1987 which gave statutory status to Lok Adalat. And that brings us to the end. I would like to thank you for your time and attention today. Thank you.